First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. Welcome to the First District Court of Appeal. We have one case on the docket this afternoon. It is Jessica Yeary versus Chief Judge of the Second Judicial Circuit, 21-2583. Mr. Knowles, you may proceed when ready.
May it please the court. Counsel. Good afternoon. My name is John Knowles, and I'm here on behalf of petitioner Jessica J. Yeary in her official capacity as the public defender for the Second Judicial Circuit. I'd like to reserve 3 minutes of time for rebuttal. Administrative Order 2021-06, issued by the Chief Judge of the Second Judicial Circuit, impermissibly alters the legal framework for setting conditions of pretrial release for an accused in the Second Circuit. Although the administrative order may be well-intentioned, it places some people accused of crimes in the Second Judicial Circuit at a disadvantage not suffered by any other accused in the state of Florida. Nothing in the text of Florida statutes or Florida rules of criminal procedure authorizes the ordering of a pre-bond screening. This administrative order creates a new mechanism not found in Florida law. The term does not appear anywhere in Florida law, and all of the necessary mechanisms to address the concerns in the administrative order already exist in Florida law.
Is there any judicial proceeding or quasi-judicial proceeding under review in this case?
Judge, there are other matters under review. Habeas petitions have been filed in other cases.
No, I mean in this case, are you asking us to review anything in a judicial proceeding?
No, Judge, just the validity of the administrative order on its face as issued by the Chief Judge of the Second Judicial Circuit.
So the petition itself, doesn't that turn everything that we know about certiorari on its head?
Judge, respectfully, I don't think so. I think all of the prongs for certiorari relief have been met. I think the departure from the essential requirements of law is what we're talking about in terms of the modifications that are made to the Florida Rules of Criminal Procedure.
Right, but what I meant was is the Supreme Court in DeGroote in the 1950s described certiorari as something that's used to review judicial or quasi-judicial proceedings. So I'm curious, what is it that we're reviewing here?
Judge, I think since, I believe it was the Wild decision in the 90s, since that decision, there seemed to be a line of cases which petitioners cited to that stand for the proposition that an administrative order is subject to certiorari review and that is the appropriate avenue.
Right.
Well, isn't it a judicial order? It's an act of judicial power.
It is, Judge. It's unique in that it is not in ongoing litigation. A lot of the certiorari cases deal with non-final discovery orders. I believe respondents cited to Tavanese that was dealing with whether or not the state was deprived of a discovery, of appropriate discovery, trying to seek medical records, and there that was a little different in the context of ongoing litigation. Here, it is judicial action, but it's different qualitatively from what we're dealing with in a lot of the other certiorari cases.
Yeah, I mean, what DeGroote may have said 70 years ago, our Florida Supreme Court said in 1999 that this type of thing is reviewed by certiorari in the 188 traffic school case, correct?
Yes, Judge, that's correct. And I think the 188 traffic school case indicated that there are only specific things that are subject to certiorari review by the Florida Supreme Court, and that's judicial assignments. It seems that since that case, a number of administrative orders have been subject to challenge through certiorari review.
Did the Supreme Court even have the authority to issue an opinion in 188 traffic? Because it was a transfer from this court as a certiorari petition. The Supreme Court in that case acknowledged that it lost cert jurisdiction in 1980, and then it transferred it back to the DCA. So how is that binding precedent if the court didn't have jurisdiction to consider the case in the first place?
I think that was the distinction, was the Florida Supreme Court was saying they only had certiorari jurisdiction in very limited set of circumstances.
Well, Wild was prohibition, just to be clear. Wild involved a writ of prohibition.
And Judge, they didn't pass on the merits of the what was being sought as relief there. So I don't think that the traffic school case necessarily stands for the proposition that this court does not have jurisdiction to review the administrative.
Well, in fact, if you look at it, it was on remand here. This court acted upon the petition for certiorari and dismissed the relief sought. So that they had jurisdiction, they acted upon it.
Yes, Judge.
Right.
And I think there is jurisdiction, and I think the cases that flow from that point indicate that the administrative orders are subject to that sort of review.
It seems to me a question that on my mind is this irreparable harm question about, is the public defender of the Second Circuit having some irreparable harm, or is it the client having irreparable harm, or is it the office having irreparable harm because they can't get notice about the proceeding to mentally evaluate their client, or they can't be present and so forth. I'd like to hear some more discussion about that aspect of it.
Yes, Judge. I think I would point the court to the Holt and Valdez cases in terms of what is significant about the analysis here in that the petitioner is bringing this action in her official capacity. I think the Holt case specifically is very close to what we're talking about. In that case, the decision indicates that the public defender was bringing the action because parties, attorneys, and members of the public were being harmed. So it wasn't necessarily even that it was a client of the public defender in that case that was being harmed, but that the administrative order itself caused harm by they weren't granted certiorari relief because in that case the court found that the administrative order was within the rules, but it still, I think, stands for the proposition and the precedent that even if the petitioner herself does not suffer harm, this court can still pass on the validity of the administrative order. But I would also point to the Valdez case in which modifications to the pretrial release statute were implemented in an administrative order and added conditions that were not present. And in that case, the court indicated that even though the individual petitioner's cases had been rendered moot by them being afforded relief prior to the decision, they decided the case based on the potential of future enforcement of the administrative order. I would also suggest that petitioner is affected, that the irreparable harm here is that as a constitutional officer, she is tasked with carrying out the representation of indigent clients.
Well, counsel for the chief judge says that this should have been brought in a habeas with a real client and a real set of facts.
Yes, Judge.
What's your answer to that?
Well, one, the administrative order, had no one been affected by it within the first 30 days of rendition, could have been not subject to challenge under certiorari relief. So there's the potential that a person isn't even affected within the appropriate time frame to bring the action challenging it on its face. But two, I think the court has the opportunity, like the court in Valdez, to not address this piecemeal through individual habeas petitions. That this potential of future harm is evident from the inability of a person affected by the administrative order to get relief fast enough, because we're talking about something that is essentially so quick a turnaround that the habeas petition is rendered moot by the time that the person is eventually brought back before the first appearance magistrate and granted relief.
And my understanding that in most cases that's the next day, right?
Potentially the next day, Judge, sometimes 3 to 4 days. It depends and it varies, and a lot of this, pragmatically speaking, is dependent on the availability of a person to conduct the evaluation or the screening. And so from a practical standpoint, it could be a day, but it could be 4 days. But even if it's 4 days, it still keeps that person from having their constitutional right to the determination of pretrial conditions of release under the state and federal constitutions.
Where's the source of that? So what is the actual time period that someone has to, constitutionally is required to get bail conditions?
Well, Judge, I don't know the answer to the constitutional question, but Florida has made a policy decision in the promulgation of rules that a first appearance magistrate...
Well, it can't be a policy decision because it's by rule, and the Supreme Court doesn't have the authority to establish policy by rule. So what's the source of this substantive right to be considered for conditions of bail or get released on bail within, 24 hours?
Yes, Judge. Well, I think the cases that I've cited to dealing with a person's right to release don't indicate a specific time frame, but I think that the liberty interest, there's no de minimis exception to somebody's liberty interest, and that the Constitution guarantees a person the right to release, and I don't think there is a specific time frame necessarily that's laid out in the text of the Constitution, but the rules still mandate that a person be seen by a first appearance magistrate and have their conditions of release addressed within those first 24 hours. And that's where the administrative order here goes astray, and that it alters those rules that are promulgated. So,
Right, and what specific provision in the AO prohibits that from happening? I mean, specifically, that precludes a duty judge.
Precludes a duty judge from setting conditions of release?
Right, from considering conditions of release or seeing that person within the first 24 hours, as you described.
I don't think the administrative order prohibits that, but
Right.
what it does do is it enlarges a first appearance magistrate's ability to go outside the rules in terms of what the time frame is.
Right, which provision does that?
The provision that extends allows the judge, paragraph 5, that the presiding judge may order a brief continuance to align with the rule regarding a probable cause determination, which is contained within Rule 3.133, which is a separate analysis from the rules regarding first appearance in 3.130 and 3.131, conditions of pretrial
Are
release.
you contending that without this AO, a duty judge has no discretion to continue a bail hearing?
Yes, Judge. I think that the first appearance magistrate is bound by the timeframes set out within the Florida Rules of Criminal Procedure. I would analogize it to the rules regarding speedy trial. This is not some discretionary relief. A person is entitled to reasonable conditions of release. Whether there's a specific time frame that the Constitution allows, I don't think is necessarily what's before the court. But those constitutional rights that are logistically implemented through the rules of criminal procedure lay out specific timeframes, and there are reasons that those timeframes exist because these are self-executing constitutional rights. A person has a right under the Constitution to a speedy trial, and a person has a right under the Constitution to reasonable conditions of bail.
Do you acknowledge that mental health is a fair condition to be considered in connection with bail?
Yes, I think I'm sorry, Judge.
So, and if that's the case, you're saying that, so the duty judge has to make an on-the-spot call whether this person is suffering from a serious mental illness
Yes, Judge. And I
without
think
any evidence or any other source of anything, and aren't you arguing then that the default would be to deny bail out of a concern, whether it's justified or not, out of concern that there's a serious medical issue?
No,
Or
Judge.
pose a danger to the defendant himself or to
I'm
the
not,
public?
sorry.
No, go ahead.
Judge, I don't think that I'm definitely not arguing that a person would not be entitled to bail, but the text of the rule, 3.131B2, indicates that the court has to consider all available relevant factors, and so that necessarily limits the amount of information. And I see that I've run into my rebuttal time, so.
You can keep going. Anything else you need to say, or if there are any other questions? I'm not going to be restricted with time on this because this is important.
Yes, Judge.
What about the delegation of authority to a criminal case manager or even the booking officer to invoke this procedure? Maybe you haven't addressed that in this particular case, but
Yes, Judge. And that's problematic for a number of reasons that I think are addressed in the amicus briefs, but we've focused on the procedural aspects of this in the petition itself. But I think that goes, again, to the irreparable harm in that if the judge delegates this task to a non-judicial official, they're sort of engaging in fact-finding in terms of whether or not somebody even needs to qualifies, and there aren't real standards laid out here in the same way that, for instance, a competency evaluation might be ordered, where there's specific language and specific standards that guide whether a court should order a competency evaluation. And so delegating that authority to a person, by the time that has actually happened, that bell can't be unrung, and any damage that's done from that person making a judgment call about whether the person needs to undergo this screening or evaluation, any information that's disclosed or any information that is used in that evaluation, I don't think individual petitioners would have any adequate relief on direct appeal, and so they would be harmed, and petitioner here would be harmed as a person who is obligated to represent people who have been arrested and who are indigent.
so the power, the power under this administrative order is given to these pretrial release officers, Second Circuit criminal case manager, and booking officers to make a communication saying this person needs to be evaluated, and then that process is initiated. There's no judicial act at that point. In other words, the first appearance judge isn't even involved in that at all, right?
That's correct, and potentially petitioner here would not even be involved or be notified in some
And
instances.
counsel wouldn't know the potential.
Correct.
Because the detainee does not even have legal counsel assigned to them if they're indigent. at this
Correct,
point.
and under the, I believe it's Rule 3.111, a person who is in custody is entitled to have an attorney appointed if they are not able to afford one.
Has anyone ever challenged the decision that's being made by these individuals, pretrial release officer, Second Circuit criminal case manager? Have you all ever challenged their decision-making? Like, that's...
Well,
All
Judge,
wrong.
practically speaking, I don't think that we've seen that situation, at least not since the issuance of the administrative order. And I think that demonstrates the problem with those individuals making those decisions. So I see that I've.
Does the public defender separately provide mental health services of some sort to clients?
The public defender here, the petitioner, would provide potential support services, Judge, but I don't think necessarily what we're talking about in terms of the pretrial services monitoring as a condition of bail. There may be conditions that are, like the court indicated earlier, that is a relevant factor for a first appearance magistrate to consider, and there may be conditions that are ordered that deal with that concern for somebody who is potentially maybe displaying signs of mental illness but not so serious that they're subject to involuntary examination.
So what about so conflict counsel or private counsel who is appointed under the JAC? If they're appointed, maybe they get retained early enough to meet with the client, and they have a concern about mental health. What resources are they going to turn to get a screening or something to help them? Maybe they determine that's in the best interest of the client to be detained instead of being let out. I mean, the public defender has a lot more resources than conflict counsel, and certainly more than folks that have to turn to the JAC. So what are they supposed to do if the circuit court's not providing those resources?
Yes, Judge, and I don't want to paint the impression that the public defender has a vast amount of resources. That's certainly not the case, but frequently I think any attorney who is in this situation may have to turn to community resources, try to connect people with other services that they don't even have control over, so that they're limited in their ability to provide those services. But the question is still, what conditions can assure a person who's in this situation returns to court and is not a danger to the community?
Sure. And so, I mean, isn't one reading of this administrative order that it's the circuit court providing more services and resources to defendants that might not otherwise be available?
Judge, I don't think there's any problem at all with the court, a first appearance magistrate, saying, based on the information available to me now, I'm going to order conditions of release. The problem with this administrative order is the detention that it causes when a person is held over to undergo the screening. So,
Sure, but any particular duty judge is not required to detain that person. That duty judge can say just all the things that you just said. I have a concern about mental health, but I'm not going to hold them over while I get the screening done, but I order you to get the screening done within 24, 48 hours, right?
And if they're not held over, I think that presents a separate issue of whether the screening itself is harmful and whether they're being detained in violation of the Article 1, Section 14 right to release. And so there's separate issues of what conditions are ordered in terms of release. And I don't think there is anything requiring a first appearance magistrate to hold somebody over. It's the danger is that somebody could be, and it could be based on a completely subjective evaluation of a person, someone who's acting strange or weird, and there's not a guideline here for a non-judicial officer to make a determination, or even at the first appearance itself to kind of guide us through that. And those mechanisms for a person who's displaying such serious concerns or such serious signs of mental illness already exist through Chapter 394. And so this is implementing a new mechanism where we already have mechanisms to deal with the situations where it rises to that level of concern.
Any other questions? Okay.
Thank you.
Thank you, Mr. Knowles. Okay, so by my math, you used your 15 minutes and you went over by 4, and I'm going to give you 3 minutes for rebuttal. So that's 15, 22 minutes. So, Mr. Stafford, you will have 22 minutes. If you choose to use it, you're not required to use it all, of course.
Your Honor, I don't believe I have 22 minutes of material, but I will be judicious in my time. Your Honors, I'm Bill Stafford of the Office of the Florida Attorney General on behalf of the respondent, the Honorable Jonathan Scherstrom, Chief Judge of the Second Judicial Circuit. As set forth in our response, the respondent's position in this case is twofold. Number one, that this petition should be dismissed because it fails to meet the elements required for a petition for certiorari, and second, if this court determines that there is jurisdiction, that the petition should be denied because it fails on the merits. First of all,
What do you think the nature of the administrative order is? Is it judicial or is it administrative?
it appears to be some hybrid. I would say it tends more on the administrative side because the petition or the administrative order, the continuance that's authorized or recognized in the administrative order is a last resort. The AO first permits the case manager or jail booking officer to recommend or order a pre-bond screening as part of the information gathering process. And then once the hearing commences, it imagines that the public defender or counsel for the defendant or the state attorney can also recommend or move for a pre-bond screening with the attendant continuance.
Well, what I mean is does the order adjudicate anyone's rights?
I don't believe so.
I don't think so either. So, and can anyone besides the chief judge or acting chief judge issue an administrative order for the Second Judicial Circuit?
No, Your Honor.
Right.
Well,
So-
I'm sorry, go ahead.
So, I mean, isn't this order issued by the chief judge purely in his administrative capacity as designated by the Constitution? Like, I guess I'm asking, I'm not sure what the hesitation was when I asked, like, is this an administrative order or is it a judicial order? I mean, my understanding of the exercise of judicial power is the adjudication of rights between two parties. And this sounds a lot more like the chief judge acting in his administrative capacity running the circuit court. Am I missing something on the
No, Your
nature
Honor.
of this order?
As you explained, with that understanding, it is administrative because it would apply to more than one case. It's not adjudicating rights of any parties before the court at any particular time.
But couldn't you look at the order and say, wait a minute, doesn't it just basically across the board adjudicate all criminal defendants' rights to counsel before having a mental health examination? In other words, you have a swath of people who are arrested or detained, and they're now being subject to these mental health examinations. Hasn't there been a judicial determination and act adjudicating that they do not have the right to have a lawyer present and appointed to them during this process by which their mental health will be questioned without any legal counsel on their behalf?
Your Honor, I would respectfully suggest that the order does not prohibit counsel from being involved. And that would be one of the reasons why this should be.
Well, how does that happen? As I understood it, at least in this case, there is no lawyer appointed at the time this can be applied, this policy is applied, this order is applied.
Correct, but if the defendant invokes, for example, invokes a right to counsel, or in the event that there is private counsel.
They already have the right to counsel. Do we agree upon that? Every one of these individuals subject to this mental health evaluation, before that occurred, had the right to a lawyer?
Yes.
Okay.
Yes, Your Honor.
And these decisions are being made without criminal defense counsel being involved?
Yeah, potentially, yes, Your Honor. I mean, yeah, obviously there is a right to counsel. What right has not attached at that time is the right to appointed counsel for indigent defendants.
See, my concern is, certainly, Rule 3.130 requires, a first appearance within 24 hours, and that first appearance, the first appearance magistrate is supposed to set your conditions of bail. Okay, that's fine, I understand that. And certainly a first appearance magistrate can have a continuance of that process if there's a reason, and there has to be judicial findings. The judge has to find there's a good reason why I need to continue this. This is kind of a blanket policy that says we're going to do this to everybody, or we're going to do this to people when they are identified by people that are not judicial officers who are not making judicial findings. And we're going to drag out their first appearance for 48, 36, 72 hours maybe. And I'm just trying to find how does the chief judge have the authority to not only make a across-the-board blanket decision for all this class of defendants and not individual determinations, but to delegate that to non-judicial persons?
Well, Your Honor, I would respectfully suggest it's of a piece with the entire procedure before first appearance. One of the things that the jail or the booking officer or case manager is required to do in order to facilitate first appearance is to gather facts, and as set forth in the facts that are required for a court to consider in order to determine a pretrial release conditions, or whether or not the pretrial release would be authorized. Most of those, such as family condition, job, those are things that can be verified and do not require any, can be done by a layperson. What this order...
Yeah, this may be a really good idea. I'm just trying to square it with Rule 3.130. I mean, maybe the Rules Committee should look at this procedure statewide, but Rule 3.130 says that you have a first appearance within 24 hours, and there's a bunch of things that have to be done, and one of those things is set conditions of their bond. And this seems to be a policy that says you don't need to worry about that. We can hold this person over for 36, 48, hours until we get this procedure done to them.
Well, the administrative order, it's just to be clear, the administrative order does not authorize a booking officer or case manager on his or her own to authorize a continuance. A pre-bond screening that would be ordered by the case manager or booking officer is intended to be accomplished prior to first appearance. The administrative order does not authorize the start of a first appearance to be continued. The order says this decision can be made during the first appearance.
What you're saying is within that 24 hours, the defendant goes before a magistrate, and even if this screening was ordered, the magistrate has to make an individual determination on whether they're going to continue it to get more information or make the decision right there.
Correct. The decision on continuance cannot be made by a booking officer or a case manager. The case has to proceed to first appearance and the beginning of the pretrial release hearing. Only in those cases, if circumstances warrant, if there is good cause, then the court can order a continuance for 24 hours in order to get that pre-bond screening that's done by a licensed psychologist that's already been certified by the court.
Who pays for the psychologist?
Say again, Your Honor?
Who pays for that psychologist?
It's not set forth in the order. There is no I can say that there is no requirement for a criminal defendant to pay for that.
Does the circuit court provide it?
As I understand it, the psychologist is under contract with the court.
Okay, and that's a contract separate and apart from this AO, is that right?
Correct.
So if the administrative order went away or if it never existed, what does that world look like for a defendant who has a mental health, potentially a serious mental health issue that may affect the conditions of release? What does that world look like?
Well, I guess it would all depend on the nature of the relief ordered by the court.
No, just pretend that the order
Right.
doesn't exist. Just alternative universe,
Right.
or maybe before the administrative order was issued.
What,
Were judges not allowed to order mental health screenings if they had a concern and couldn't assess for him or herself whether
They
this
were-
person had an issue?
They were, Your Honor, as set forth in the preamble to the administrative order, also as acknowledged by the public defender in her petition, that this has been a practice of the Second Judicial Circuit for decades. What the administrative order does, among other things, is essentially to codify the pre-existing practice, which would make sure that all judges do this in a similar fashion, especially for circuit judges who don't regularly attend or preside over first appearance. Just to have this order to say this is how we've done it in the past, and this is how we're going to continue to do that.
Was the circuit court paying for the mental health professionals before the AO when it was just tradition?
There's once again, there is no record, but I would represent that is the case.
So you said in the brief that this should have been brought as a habeas petition with a real defendant and someone who's being held. How would that happen? Being that we're talking about the difference between being released after 24 hours or being released after 48 hours. How would we get a response from the state and then adjudicate that in that amount of time?
Your Honor, I would say that as the previous petitions filed by the public defender, these would fall into a textbook case of capable of repetition yet evading review, which would provide the method for the court to for this court to review those cases based on an actual record.
Okay.
And I would invite the court to consider the Greenwood case cited in my response. That was a challenge to the procedure used by the circuit court to determine pretrial release. And in that case, the second DCA found habeas as the proper procedure and noted that the case was not moot because it was capable of repetition yet evading review. And having a habeas petition as opposed to the certiorari petition we would have a record, we would have evidence of how this rule operates in practice, the actual length of time of any continuance, and the circumstances that would generate an order for a pre-bond screening, and the result of that screening, whether that in fact led to a release of a defendant pretrial on non-monetary conditions because their mental health has been subject to evaluation. It's our position that Section 907.041 requires, as a prerequisite to release on non-monetary conditions, that any mental health issues be evaluated and verified by pretrial services.
Is there anything that stops the booking officer or the deputy at the jail or someone on staff at the jail after the person's arrested, after they're booked, while they're awaiting first appearance? Is there anything that stops someone from the jail from doing a mental health screening?
From doing a mental health screening? No, Your Honor. In fact, that is envisioned by the administrative order, and that is I would suggest that is the preferred method.
Well, the AO only anticipates that the booking officer could make a request for a screening. What I'm
Correct.
asking is, and that would be a request, I guess, to someone on contract with the circuit court. I'm asking whether is there anything that stops the jail or the sheriff or having mental health professionals on staff and they do their own screening, for the safety of the jail or something like that?
I don't see anything based on the administrative order and
But the question is, what authority is there for doing that? This is a great idea, it's wonderful, but where's the authority granted to the circuit court to do that?
to order a pre-bond screening.
No. I mean, I understand with the administrative order this can be done. But I understood Judge Tannenbaum's question to be something different, which is that without the order, couldn't this circuit just have a mental health expert go down and talk to folks who are being detained to assess their mental state?
I would not see any prohibition on that, but I understood
That's right.
understood
No,
your
I'm
question to be
asking-
whether the jail could do that on its
Right.
own.
Yes, whether the sheriff or whoever operates the jail, I think it's the sheriff, whether they could have someone screen for the safety of the jail. They need to decide for security purposes which pod to put that person in while, waiting for first appearance. Could they do that? Or is there anything that stops the jail from doing it? I don't know if they do it now.
I'm not aware of anything, but that was not a issue that was raised in the petition. So it would be speculation on my part, but it would be my understanding that a jail or pretrial detention facility would be well advised to have mental health resources available, considering the fact that there is a lot of mental health issues in the jail and pretrial detention populations.
Right, and that gets to my larger point, is what do you think the purpose is behind mental health screenings? Do you think it's to do interrogation and get free incriminating information on the defendant, or do you think it's to provide services and help for someone potentially in need, to protect them from themselves and potentially from other people?
Well, that is the nature of I'd suggest the nature of the administrative order is not to seek to detain individuals. It's to seek the ability to release them on non-monetary conditions and, based on the mental health evaluation, make that release subject to mental health treatment. That would both serve to protect the community, ensure the presence of the defendant at trial, and in addition, potentially have this defendant receive mental health treatment, so in the future he or she might not be back before the judicial system. I think we can all recognize that the pervasiveness of and the connection between mental health and criminal behavior. So if this can contribute to that, then I think that is all to the good.
But the point here today, though, I mean, I agree with all that. I think we all would like to have more mental health services for society and generally. But the point today is the right of these folks over here, the public defenders, to have their clients be represented before these decisions are being made, before these mental health evaluations are imposed. As I understand it, and I was on the panel in Wallace, okay, where a case came to us on a habeas, and at that point, the public defender first learned about this at first appearance, so everything had already happened. Someone had decided Wallace was going to have a mental health examination. I think it may have already been done. I'm not really sure. I have to go back and check. But the point of today's discussion is, doesn't the order prevent a criminal defendant from having counsel available before the whole process plays out? Because if it plays out as it did in Wallace, it was moot. And yeah, it could be capable of repetition or evading review. And in fact, I think the parties in Wallace agreed to consolidate that case with this case. My two colleagues didn't agree with that, or otherwise we'd have both cases here today. But it seems like in the habeas context, there's going to be a couple of significant hurdles to ever having a case come to us, unless a panel in its discretion, and we didn't in Wallace, maybe another three-judge panel might exercise the discretion to say, yeah, we think it's capable of repetition but evading review, so we're going to retain jurisdiction. But it's an important issue, so should we leave it just the habeas, or we're here today on certiorari? Why shouldn't we hear it today?
Well, I think another, I think one of the issues with respect to proceeding with this as certiorari is you also have the element of whether there is irreparable harm to the petitioner herself, and we certainly submit that that is not the case here. With respect to counsel, there is, again, as the court recognizes, this would occur, if it occurs prior to first appearance, it would occur prior to the appointment of counsel. While a defendant certainly has a right to request counsel, there's simply not a right for a criminal defendant who is indigent, a right to have counsel appointed for them.
Well, I thought we already decided that they're entitled at that point. Once they're detained, they're being held, they have a right to counsel.
Yes, Your Honor.
And that counsel would advise them about this process, this mental health evaluation process. I mean, if defense counsel got involved from the very start and learned that there was going to be a mental health evaluation, could they say, well, I object to this, I don't want there to be disclosure of information that could prejudice the case, I want to advise my client about this? I mean, none of that's going to happen, as I understand it, under the way it's currently administered.
That's potentially correct, Your Honor, but there is, well, I think one thing to consider is the administrative order expressly prohibits the use of any pre-bond screening for anything beyond making a determination as to pretrial detention. And, of course, if there were any statements that the state attorney tried to use from these pre-bond screenings, it would certainly be subject, if there was no counsel, subject to the exclusionary rule, either the Fifth or Sixth Amendment, the remedy of the exclusionary rule.
Could the defendant, whether he or she didn't have a lawyer or not, object to the examination and say, I'm not going to do it?
There, I believe the administrative order requires that a defendant be advised that he or she has no, can certainly maintain their right to silence.
That's in the order? I'm sorry, I must have missed it.
Say again, Your Honor?
I didn't know it was in the order. I'll have to check that.
What's the consequence if a circuit or county judge doesn't follow the administrative order? To the extent that it's possible to not follow it, since it's really not directed to any trial judge in particular. But let's assume, I don't know, I assume that's why we're here, is there's an assumed consequence or an assumed, the assumed fact that a judge is just going to follow this blindly without exercising his or her own discretion. So what would be the consequence of ignoring the AO?
Your Honor, I would suggest that the AO is not, the nature of the AO is not mandatory. It is permissive. It says the court may do this. It doesn't require the court to grant or to order on its own a continuance. Only says if you observe or if a booking officer has noted behavioral indications of a serious mental illness, then the court may grant this continuance. There's no requirement that the court do that. The only requirement is that a court evaluate the factors set forth in 3.131 and 907.041. Consider those factors before making a pretrial release decision.
Thank you, Mr. Stafford.
Thank you, Your Honor.
Set Mr. Knowles' time at 4 minutes.
Thank you, Judge.
And of course, the same rules apply.
Yes, sir. I want to address, Judge Roberts, your sort of points about the extension of time first. I would suggest that there's nothing in Rule 3.130 that goes to continuance of the first appearance for good cause. And to the point of that may be a good idea, that's a question for the Rules Committee. But I would say that that should be compared with Rule 3.132, the pretrial detention motion, which lays out specific timeframes when the state is seeking to detain someone, within which they have to show exigent circumstances or indicate to the first appearance magistrate that they intend to seek pretrial detention. But nothing in Rule 3.130 itself grants an extension of time even for a showing of good cause.
Yeah, but what about Rule 3.050 that gives general authority to extend deadlines generally to trial judges?
Yes, sir. That rule specifically in both subsections 1 and 2 requires that it's on the request of a party. If the time frame has not yet expired, it's upon request, or if the time frame has expired, I believe there has to be a showing that it was not due to excusable neglect. And so to the extent the administrative order conflicts with that by saying it can just be granted without a movement requesting it, I don't think that 3.050 permits that extension. I'd go back to the speedy trial rule and say we wouldn't extend the speedy trial rule outside that specific framework of timeframes that exist in that rule. That specific provision controls over the general rule in 3.050. Also,
Go ahead. I'm sorry, I don't want to interrupt you answering Judge Roberts' question.
thank you, Judge. The cases that the respondent cites to all seem to deal with permissive relief and in a post-conviction context where someone's seeking something that is not a mandatory sort of relief, where a person must have their bail conditions of bail set, apart from certain exceptions, as opposed to someone who's seeking correction or modification of a sentence. So I think those are qualitatively different. And
What's the answer to the question that I asked before, Mr. Stafford? What's the consequence of, my understanding, I think I read this in the Constitution, that every circuit and county judge is an independent constitutional officer vested with a certain amount of judicial authority of the state of Florida. What's the consequence if a circuit or county judge doesn't, I don't know, quote, follow the AO and perhaps exercises his or her own discretion and continuing or not continuing a bail hearing?
Judge, I believe the rule, and I don't have this provision in front of me, but I believe a violation of an administrative order is required to be reported to the Supreme Court. That's off the top of my head. But the provisions here, I don't think, as the respondent indicated, with the permissive language, the only situation in which I can think that might become a problem from our perspective is if it's continued beyond the window which the administrative order lays out. So if a first appearance magistrate were to continue the proceeding beyond even the window of the probable cause hearing.
Okay. And looking at the AO, looking at the people I think who are directly affected by it potentially, so you have your pretrial release officer, your criminal case manager for the court, and the booking officers. Now, I'm assuming the booking officer works for the jail or for the sheriff, right?
Presumably, Judge.
Okay. The pretrial release officer?
Pretrial services program.
Okay. And they are under the chief judge?
The pretrial services officer, yes, I believe that would be correct.
So they're part of the court?
I think so, Judge. Off the top of my head, I think that would be
Okay.
correct.
And I'm assuming the court criminal case manager works for the court,
Correct.
right? So is it your position that court staff and officers of the court cannot talk to a defendant without a lawyer being present?
Well, I think this goes back to kind of the distinction you were making between someone can talk to a criminal, an accused, to determine whether or not there's a safety issue at the jail. That's different from going into information that may be tangentially or directly related to the accusation in the criminal case.
Well, is there any indication that that's specifically what happens? I mean, maybe it's tangential and accidental, but isn't the primary purpose of these mental health screenings is to determine whether this person is a danger to him or herself or to others for purposes of fashioning conditions of release?
Well, the court's question about the intention earlier, I think, is what that gets to, which is whether or not the intention is to interrogate or to make a safety evaluation. The reality is the information that's provided. If a person refuses to participate in practice, their records are still disclosed, a report is still generated, and it's made part of a court file that is permanent. It's
Right,
unlike.
and you're saying the court doesn't otherwise have access to any information in the course of a proceeding, in a criminal proceeding?
In certain situations, they would, Judge, in the context of a competency evaluation, or if they ordered an involuntary examination under 394.
And I don't remember anyone challenging that process where the court, would actually have access to, mental health records of a defendant. I'm assuming because we trust our courts to, do what is appropriate with that information and not misuse it or use it in an incriminating fashion in a trial, right?
Yes, Judge, but I think that all takes place in the context where an attorney has been appointed to represent the person, has had the benefit of counseling them and having adequate time to review the situation and provide solid legal advice. So all of those contexts, I think, differ from what we're talking about, which is the first appearance consideration.
Would a confession be discoverable during the course of one of these mental health?
Well, I think that's the problem with the process in practice is by the time a confession could have happened by the time that the report is generated and the damage is done, whether or not it's excluded from evidence, the state has the benefit of the information and the accused is immediately placed at a disadvantage from the outset without having had the benefit of counsel.
Well, is the concern then that the state gets a copy of the report or has access to that kind of information without it being redacted, or is the concern that someone's sitting down with a mental health professional, presumably to help the defendant, without a lawyer present? And I'm not sure, quite frankly, what the lawyer is going to do while sitting there listening to the mental health evaluation, so maybe you can enlighten us a little bit on that.
I would say it's one of the concerns, Judge. There are many concerns, and the amicus briefs kind of deal with that issue of what information is being provided versus the procedural, the rights that are being deprived at the first appearance process.
Wasn't the risk, aside from trying to make a point, isn't there a risk that actually the defendants will be hurt by getting rid of this? So you have individuals that are going to go before a duty judge, and there will be no information about the mental health background, and you have a judge that's trying to make a spot call in a very busy docket, eyeballing the person for a few seconds or a minute, and going on instinct, and they're going to err one side or the other, and if the person gets, so one option is to release them on conditions, and maybe they have a serious mental health issue that's now not going to be addressed, or maybe they err on the side of keeping them detained when they don't have a serious mental health issue, and they still don't have a screening, and so we don't know whether that person's being improperly detained.
No, I don't think it helps the accused. And I think outside of the specific exceptions, the person would not be permitted to be detained. And the court already has the option of ordering mental health pretrial release and conditions that address all of those, but with the benefit of counsel after the fact, so that if the propriety of those conditions changes, their attorney can ask for modification. Thank you.
Well, counsel, we kept you here a lot longer than we told you you would be here. We appreciate your oral arguments, and we are adjourned.
All rise.